We're live, Mr. Chairman.
Good afternoon. It is the 5th of April, 2022, and this is the House Judiciary Committee. We have a number of Senate bills we're going to be hearing today. I think most of them are sponsor only, but let's roll through them and find out. So we're going to start with, I don't see Senator Waldstreicher.
I'm here.
Oh, there you are. All right. So we'll hear from you for 3 minutes on Senate Bill 881, please.
Excuse me. Thank you, Mr. Chairman, members of the committee. Many of you are already familiar with the issue of swatting. I know it's come in front of your committee as well. This is a behavior common in the gaming subculture as well as among white supremacists, where they call in a false report in order to draw out a SWAT team to the home of an innocent person, which of course puts that person and many other people at risk of serious injury, at risk of death. This year, a couple on the Senate side, a couple bills came in relating to swatting. And there was also legislation which you've passed and heard related to other false reports called into 911 because of someone's racial animus. That comes out of the Burden case that we saw in New York City. So because there were multiple bills and because they kind of came at this issue in different ways, our committee struggled to find a comprehensive solution to distinguish between kind of normal, everyday, routine juvenile pranks on the one hand, calls that are made to 911 for the purpose of racial animus on another, and then calls that are specifically designed for swatting in other words, to get a full SWAT team response that would endanger the lives of the people in the home there. And so because we were having difficulty drafting to distinguish these different behaviors, which we believe should be treated differently, we decided to go for a task force to better utilize the expertise in our state and come up with a more comprehensive solution. So I'm not in love with task force, and I'm certainly not in love with them in an election year, but I will sit on this task force if it's passed, and we have other volunteers from the Senate side to do the same in order to come up with a more comprehensive solution and come back with one voice instead of multiple bills. And so that's what Senate Bill 881 does. Thank you, Mr. Chairman.
All right. Are there questions for Senator Waldstreicher? Do you have a whole lot of heartburn if we just remove the legislators altogether, and because we've been kind of doing that as a committee to the work group meetings, and then if legislators want to attend, they can go ahead and attend if they want, just striking them so that it's a little easier to get these things up and running.
Yeah, I mean, that's fine by me. I defer to you. I think a lot of the folks who have been involved in this issue are members from Montgomery County, whose fate will be determined in July. And so we may have more time than others, but I'll defer to you, Mr. Chairman.
That's all right. Thank you for that. Delegate McComas has a question.
Delegate Waldstreicher, what are the parameters that the task force is going to look at? Because I would hope that they also would be looking at if somebody does that and they're able to find out who it is, that they can prosecute them, if they have the evidence beyond reasonable doubt. I haven't had a chance to look at the bill. I apologize, but I hope that you kind of look at that as well when it's all
how to locate the culprit.
Well, how to locate the culprit and also how they, what type of punishment they should receive. I mean, I think it's serious because I remember a long time ago when the mayor of, I forget where it was, they came in and they shot the dogs and they had nothing to do with it. You may have been on the committee at the time.
I remember that. Yeah, I think it was the mayor of Burnwood Heights, if I'm not mistaken. But yes, the task force will be looking at that.
Okay, thanks.
Any further questions for Senator Waldstreicher? All right. Seeing none, we thank you very much. That concludes the testimony for Senate Bill 881. We're going to go now to Senate Bill 956, and we have Brandon Holmes, who's the aide to Senator Watson here. It's just him. We're going to hear from him for 3 minutes. Catherine Berry is unable to join us today, so we'll hear from him right now and go right ahead.
Greetings. For the record, my name is Brandon Holmes, a legislative aide to Senator Watson. I'll be filling in his stead. He sends his regards to all of his good buddies over here in the Judiciary Committee. To Chair Clippinger, Vice Chair Moon, and the members of the Judiciary Committee, thank you for the opportunity to present this bill before you all today. Senate Bill 956 is a simple piece of legislation. It expands existing state laws protecting elected officials from threats to include chief health officers for a county. This bill is not intended to stifle any free speech or debate, but instead to promote it through civil discourse as well. Some may question why we would include this category of civil servants, and the simple answer is that our counties collectively agreed that these workers experience the gravest and most frequent threats to their well-being in the line of duty. The need for this bill is so great that the Maryland Association of Counties leadership made it one of their 4 initiatives for the 2022 legislative session. Recent news and data supports this position. Since the coronavirus pandemic began over 2 years ago, the National Association of Counties and City Health Officials, NACHO, report more than 300 public health department leaders having left their post. In Maryland, 7 county health officers have already departed. At every level of government, threats have been cited as a reason for leaving. These health officers have massive responsibilities and are critical to public services necessary to protect the livelihoods of Marylanders every day. Their stories and experiences are a stark reminder of the dangerous and polarizing times that we live in, which is why this bill is so necessary. This bill passed unanimously in the Judicial Proceedings Committee and as well as unanimously on the Senate floor. And for these reasons and many others, I respectfully urge your favorable vote on Senate Bill 956. Thank you.
In mind, this is Mr. Holmes, Senator Watson's aide, and not Senator Watson. Does anybody have any hard-hitting, perhaps unfair or cruel questions to ask Mr. Holmes? No. John, the Delegate Cardin is going to take a step back on that one. All right, that's fine. Thank you very much, Mr. Holmes. We appreciate it. And that concludes the testimony for Senate Bill 956. Let's go now to Senate Bill 704, which is a cross-file of 1011 on the House side regarding electronic home monitoring. We're going to hear from Senator Hedelman now for 3 minutes, please.
Thank you very much, Mr. Chairman. Good afternoon, everybody on Judiciary Committee. I'm happy to be here in support of Senate Bill 704. All this bill does is seeks to continue a program that we started last year and this committee supported last year, which was House Bill 316. Using federal funds, we enabled the judiciary to be the pass-through entity through which those funds could go to cover the costs of pretrial home monitoring. The bill's effective date was in July, but it actually didn't get up and running until October of this past year, and it has been working well by all accounts. This bill removes the sunset of the program. Under the bill we passed last year, the program would go away in mid-August, and we don't want that to happen, both because we think it's operating well by keeping people monitored, and also there is still federal funding available. And so that $5 million that was sort of targeted to this program would all disappear if we do not take action through this bill. This is one of these issues that has been written about quite a bit about decriminalizing poverty. And we want to remove financial obligations from those people who are presumed innocent before they go to trial. And what we did last year, and this bill hopes to continue, is those people who are eligible to be represented by the Office of Public Defender would qualify for pretrial home monitoring payment through this program. Now, the judiciary is not happy about being the administrator of this program, but they have really done an excellent job, and it has worked pretty seamlessly. And it's been user-friendly. The public defenders have been able to get folks connected well as people with private counsel who qualify, who represent folks who have incomes that qualify. And the private home monitoring agencies have been working, closely with the judiciary in order to be paid. So I can tell you that it has helped about 400 people a month. The program, as I said, didn't get up and running until October, but it costs roughly $500 a month for someone to be monitored. And we estimate that since October, roughly $300,000 has been spent. So there is still more funding, we believe, available. There was also an element of the bill last year that created a work group that was never appointed by the governor. So we would like to have the work group look at longer term solutions to this issue. This bill is really a short-term fix. And the work group, we hope, would more closely examine what kind of longer-term pretrial policies should be in place statewide. So I urge a favorable adoption of this bill. Thank you.
Are there any questions for Senator Hedelman? Delegate Bartlett?
Thank you, Mr. Chair. Really quick question. Thank you, Senator Hedelman, for bringing this bill. I didn't get it. I was trying to hop over, but I wanted to make sure I could still raise my hand. So the work group is included with this bill, with Senate Bill 704?
Yes, it is.
Okay, so is one of the things that the work group will look at is let me just tell you a real quick scenario. A person would have gotten home detention monitoring, but for the fact that the judge or no one from the judge's chambers could get the home detention monitoring on the phone. So the person was sent back to prison. So my question is the work group, so I was told, so is the work group going to look at instances as to the success of the program and make recommendations in that regard? Or is it mostly about the expansion of the program with the assumption of the correct utilization of the program?
So first of all, I'm really taken aback at hearing that. And of course, that should never happen. And so I'm pretty appalled at that. Second of all, it says, and I'm just reading from page 3, line 2, the work group shall study and make recommendations regarding the costs and availability of both publicly and privately provided pretrial home detention. So the issues that you raise in my book fall in the availability bucket. So of course, I think that should be certainly one of the topics that they would examine.
Great, thank you. Thank you, Senator.
Delegate Cardin, then McComas.
Thank you, Mr. Chair. Just very quickly, thank you, Senator Hedelman. I think that the program sounds like it's working really well and we're helping people, and that's amazing. Just getting back, you mentioned, got my ears up when you mentioned that the judiciary was not happy. I just am quickly looking at the judiciary testimony, their written testimony. They were, first of all, last year concerned that the money got thrown at them late. They didn't know anything about it at first. And it seems like they're not really sure whether the money is going to be sufficient for them to do what they're doing, which it sounds like from your testimony, they're doing a great job, but they're worried. The concern remains, and the judiciary remains adamantly opposed, saying that they first tasked with setting up payment programs. Concerns were raised about whether this program is actually an administrative function or more appropriate for the executive branch. So I'm just wondering if maybe the task force can, if assuming we pass this, maybe the task force can look into that and make recommendations on how to facilitate this, or what your response might be to that.
Sure. No, I totally understand. I've had conversations with the judiciary. I know they believe this is an executive branch function. I hear them. I am empathetic. 2 things. One is they are doing it right now, and I get it. And they were involved in a conversation last year on this bill when it happened. So it certainly shouldn't have been a shock to them in October or even July, because a year ago we were having these conversations. 1, and 2 is we make it clear in the bill that that it is, this program lasts as long as the federal funds last. So we certainly do not expect them to take up the costs in any way beyond that. And yes, of course, the longer term issues will be, I hope, examined by the work group, and the judiciary's role in in this, they have to be involved in a piece of it. And I think they acknowledge that, kind of what exactly their role is and whether there is an executive branch agency or function that we can pass on to others is certainly something worthy of study of the work group.
Delegate McComas, then Delegate Howell. Delegate McComas.
Thank you, Mr. Chair. Just real briefly, it seems to me the appropriate place would be the Department of Parole and Probation, because they do monitoring and they know, there's sentence reports and everything. And I just think that would be the appropriate place. And I guess, was that ever discussed, Senator Hettleman?
So again, this is a short-term fix.
No, I realize that. I'm just kind of looking down the road.
Yeah. So longer term, that is, of course, an appropriate place worthy of further examination, definitely.
Another quick question. I noticed that the vote in the Senate, you had 11 votes, Republican votes against it. Do you know why they voted against the bill? Was it the
I do not.
Okay. All right. Thank you very much.
Delegate Howell.
Thank you, Chair Clippinger, and thank you, Senator Hettleman, for bringing this bill to us. I have a quick question. You said that the money that you had put in for last year in the task force never happened. Do you know why that never happened?
Really good question. So I think the governor never appointed people to the work group. I know the legislative, at least on my side, I can't speak for the House, but the House, the chairman is nodding his head. The House and the Senate legislative leaders appointed.
We were the first to appoint, actually, but okay.
Really? Okay. And so did we just lose that money or what happened with it?
So no, the money is still there.
Okay.
I also just learned today, in fact, that there is budget language in this year's budget to look at that and to more closely examine over the next year and to track the work product of the work group should this pass.
Okay, then the next question is the people who get selected to get this equipment, I'm assuming it's equipment to monitor, is it anybody that has a public defender or are there other requirements?
There are just, that is the people who, it's not, it does go beyond people who are represented by the public defender's office. If someone meets the income qualifications and happens to have another attorney
Okay.
representing them, they can also qualify.
Okay, thank you.
Thank you.
Further questions for Senator Hettleman? All right, that'll do then. Thank you very much.
Thank you, Mr. Chairman.
The testimony for Senate Bill 604. Now we actually have Senator Sidnor with us. And the file is somewhere over here, but Senate Bill, oh, there it is. Senate Bill 763. And let's hear from Senator Sidnor now for 3 minutes, please. Senator Sidnor.
Thank you very much, Mr. Chair, and good afternoon, Judiciary. Senate Bill 763 in its original form was a cross-file bill with Delegate Charlotte Crutchfield. I believe her bill, because of the my untimeliness, it ended up in rules. But the bill has been changed somewhat. It's a compilation bill now that combines portions of Senate Bills 587, 277, as well as 763. So this bill does a few things. One, it creates some reporting requirements by the Division of Parole and Probation dealing with certain offenders and those that they have oversight over, trying to get some additional data on them. It makes a modification to the Maryland Longitudinal Data Systems definition with respect to the inclusion of certain student data. But the bulk of the bill is a bill that deals with prosecutorial information. and transparency. So I worked along with the Maryland State's Attorneys Association as well as the Sentencing Commission to come up with some data that we believe is going to be helpful in understanding what happens with people as they are moved through the criminal justice system. The data is going to be focused on crimes where there have actually been prosecuted in the circuit court level because of some of the logistic issues that we had dealing with district court crimes. So what this bill also does is it creates a task force to look at how we might be able to capture information dealing with the prosecution of people within the district court at a future date. So the task force, I believe it has like it's just under 2 years that it will be in effect. Additionally, and I shared with Delegate Crutchfield, there were a few, I believe some minor amendments that Sentencing Commission had asked for, which after speaking with the State's Attorneys Association, I was fine with, and if made to the bill, they certainly would be considered friendly. So with that is my testimony.
Okay. Are there questions for Senator Sidnor, Delegate Crutchfield?
Thank you so much, Mr. Chair, and thank you so much, Senator Sidnor. So given that the bill is now a compilation of several bills, what was the original bill and its intent?
Right. The original bill actually gathered a whole lot more information from our state's attorneys and as well as the courts, and a good bit of that information, I believe, given the amount of data that we were looking to collect, got a lot of pushback from the court system as well as the state's attorneys. So the information that we were left with is information that everyone thought was still extremely important information. And in fact, the State's Attorneys Association worked with the Vera Institute to kind of look at the things that were most important of the list of data that had been requested, and we came up with this information. So the heart of it is still there, and hopefully with the task force we'll be able to flesh some things out a bit more in the near future.
Thank you, Senator.
Thank you.
Delegate Grammer.
Thank you, Mr. Chair. Can you hear me okay?
I can.
Question, it appears that the bill makes a change to the education article. It looks like 24701. Can you tell me what that does? It looks like it alters the definition of student data to include criminal and SINA records. Right.
And that was originally, I think, something that came out of Senate Bill 277, which was Senator McCrae's bill, which I believe that the idea was to ensure that if we're looking at, or to have a general scope of things that were going on, this particular information, I believe, the senator had wanted included. So currently under the Maryland longitudinal data system, the definition of the word student data, it specifically says that it does not include criminal and SINA records and medical and health records. So that phrase, I believe his bill, what it ended up doing was deleting criminal and SINA records, so that it's not included as, and it sounds real crazy, the data would now include it instead of it being excluded.
Okay. And just so I understand, I'm reading through the bill as you're giving your testimony here. It's been pretty significantly changed. Again, what was the intent of the legislation? Is it more of a trying to get information about crimes in regard to public safety, or?
Right. So the intent of the whole thing is we had the governor's bill, which was looking at the judiciary. This bill, the intention was to shine some light on the entire prosecutorial portion of our criminal justice system as well. Last year, we did a lot of work on looking at what happens with police engagement with citizens. So we've been focusing on the ends. We've been looking at the courts. We've been looking at the police, but rarely have we been looking at what's going on with the prosecutors and how prosecutors are doing their job. So this was an attempt to bring some transparency to that system and really do a good compilation of the data.
Okay, thank you, Senator. Thanks, Mr.
Thank you
Chair.
for your question.
Are there further questions for Senator Sidnor? As I read it, it looks like the information that would be provided is effectively the information from the sentencing guidelines sheet. Is that correct?
That is correct. And that, I think there was just a minor modifications to the sentencing guidelines.
So although, yeah, it requires, I think that something regarding whether diversion was offered, I don't think it's on the sentencing guidelines.
Right.
Guidelines sheet. So what stops someone from just taking the information that's collected here and taking docket sheets from the days that the cases were being heard and just adding judge's information and the name of the defendant?
You know, I don't know if anything would stop that, but certainly within the collection of our information, the intent is that you're not going to be able to identify individuals and the like. So
I saw that it wasn't supposed to include the name, but I don't see how there wouldn't be really anything to stop somebody from saying, oh, well, that's the case number, and it was heard on this day in front of this judge. So I noted that. I guess the other question I have is regarding the task force. It's a 2-year task force, is that right?
Right.
Can you talk a little more about, people have asked questions more broadly about the information that you're trying to get at with related to prosecutorial decisions at various steps of the process. What kind of information, or if the task force were looking to expand data collection or disclosure, are there specific things that you would be looking for the task force to actually take a deeper dive or do a deeper dive at and looking at?
Well, ultimately, we wanted to make certain that when prosecutors were using their powers, that they were doing so in a fair and impartial manner. I've had a constituent, and I'll say from the get, I don't think this bill would help in this particular situation, but I did have a constituent whose son was murdered in Baltimore County, and the prosecutor in the county, they went ahead, they were able to, they prosecuted, I think, 3 of the young men that were involved in this murder. But there were 2 others who were involved in the overall crime, which was I think it was a marijuana sale gone bad. And her son happened to be over at the home of the guys who were selling the marijuana and who were robbed of the marijuana. And they happened to be white. The prosecutor made a decision not to prosecute those young men, but prosecuted the people who had pulled the gun and murdered her son and participated in the robbery. They happened to be all Black. My constituent had a problem with the way that the prosecution used their discretion. So, I mean, in essence, one of the things that we were trying to get at was looking at prosecutorial discretion and making certain that there were no types of implicit bias and things in the decisions that are being made. I would have liked to have had an idea about whether or not charges were being used in a fair manner. But of course, like I said, this bill was stripped down pretty good, but I'm accepting of it. I understand, and I totally understand the level of information and things that I was looking for. The idea was built off of something that was going on in Connecticut, which I've been told has a different system. But what it did is it did a deep dive, and it brought your prosecutors and your judges and everyone together to really take a good examination of the system. And that's what the intent of the bill prior to it being marked up was.
So again, if there were specific subjects that, I'll talk to you offline as to whether there were specific subjects that the work group could conceivably take up. But I'll leave it at that. And we've got a bunch of other people waiting, so I don't mean to drag that on any longer than I have. So, I don't see any other questions for Senator Sidnor, so we'll stop right there. And that concludes the testimony on Senate Bill 763. We'll thank you very much, Senator Sidnor. We'll go now to Senator Carter, if she is there. One of them is her bill. The other is a Baltimore City administration bill. And I think that we have someone in the room. Well, we'll get to that bill here in a second. Senate Bill 777 is next. It's a task force bill. So go ahead.
Good afternoon, members of the Judiciary Committee and, of course, Chairman Clippinger. So I'm going to try to make this really easy and simple because I know we've all got fatigue from bills. Neither of these bills that I'm presenting today had cross files, so you haven't actually heard them before. 1 second. Can you close my door? And so you haven't actually heard them before. 777 is an Anton's Law fix. If you recall the police accountability bill that we passed last year, that was to allow for the public disclosure of police disciplinary records. And there were numerous media accounts that brought my attention to the fact that the law wasn't working as we had hoped it would once it took effect in October. And so one of the things that had come to the public was that the fees that were being charged were very erratic and sometimes astronomical fees. And so the initial bill as proposed was a bill that would have put caps on fees that law enforcement agencies could charge. Once we got to the bill hearing and heard the testimony, we learned that absolutely not one media outlet, not one civic organization. We heard testimony from Balt Legal, from the ACLU of Maryland. We also learned that even the Office of the Public Defender was not able to avail themselves of Anton's Law because agencies were simply not complying, either coming up with reasons not to comply, arguing that it wasn't in the public interest, or doing a denial, or just charging exorbitant fees. And so initially the bill had some opposition from MACO and Maryland Municipal League, and maybe some others, but we thought, and I think it was a good idea, and I know there is some kind of like task force fatigue and we don't want to do it if we don't need to, but our committee, I think, made a really good decision that these issues should be put into a task force that looks at the cost and fees, that looks at the processes and procedures that agencies use to disclose records. Some agencies, for example, were claiming that it would be astronomical fees, but the opposition or the requester was arguing that it's digital, it's a download, it's as simple as that. And so there seemed to be a need to look at the processes and procedures. There were different ideas proposed, such as, well, maybe they can start by disclosing some of the digital things, and then if there's more, they can, say, well, if you want more, it's going to cost. At any rate, the task force would include everybody from the civic organizations to the media to the Maryland Municipal League and the MACO that initially opposed it. And hopefully, after taking a look at the processes and procedures, the fees, and even the work of the compliance board, come back and make recommendations to us about what we need to do to fix this problem where we are still not, police disciplinary records are still not being disclosed under the law.
All right,
And with that, I'm happy to take any questions.
that's fine. Delegate McComas, let's start there.
Thank you, Mr. Chair. Senator Carter, I don't know what you're looking for exactly, but I would think that this would be, I know somebody has to review the record to decide what's acceptable and not to be copied. But it seems to me this would be a good job for, they decide, okay, these records need to get copied, and you have somebody that's going to school or something that loves, making copies, and it wouldn't be that expensive or difficult. Maybe I'm just a simple person, but but I just kind of like, wow. And I mean, I'm sure some instant information, that's why you need somebody to vet it, but as far as the copying, and then I'm sure everybody's going digital now like we are, so that eventually this is not going to be such a big deal, I would think.
We would hope so. And so that was exactly the argument that the advocates for the bill made. And actually it was working with the advocates and the opposition that we thought a task force was necessary. But again, some agencies are claiming that there's huge fees to produce records that are digital already. Some are not. Some are saying your request is denied because this is not in the public interest or in the interest of just the public interest. Some are, whatever the blockage is, whatever the justification is that the agency is giving, here's the end result. Not one entity has received these records as requested under Anton's law. So for that reason, I just think that we need to figure out how to make it better and, not just kind of willy-nilly do what I wanted to do, which is say, let's just put a cap on what they can charge. Let's really look at what are the costs, what is involved in the process of producing the records, how expensive is it to produce it? How expensive is it to copy it? Are there ways that they can parcel out some of the expenses? All of those things I think need to be looked at, as well as, frankly, maybe even if we need to tweak the language of the law so that justification or that denial based on not in the public interest is not always used as a reason not to produce the records.
Delegate Bartlett.
Thank you, Mr. Chair. Thank you, Senator Carter, for this bill. Because I do want to know why it's so expensive and why no one can get the records. I have a question about the very last part of the bill. I see that this December, there'd be an interim report. Next December, there'd be a final report. And then there's a time period for almost a year and a couple of months after that. What's happening for that year and 2 months between December 2023 and February 29th, 2024? Is that just to allow in case the report is not ready? Why is there such that long period of time, and what's supposed to happen then?
So I believe that was a committee leadership decision and above my pay grade. However, I'm going to imagine that they thought that if the final report is due December 2023, that setting that February 2024, that would hit us in legislative session. It would kind of prompt some legislation that year, I'm guessing. So.
Oh, and actually, yes, you're right. And I did my math wrong. It is February, so it is only January and then February. So yeah, that makes sense. Okay, thank you, Senator Carter.
Thank you.
Further questions for Senator Carter? Sorry.
What an honor to be mistaken as Senator Cardin.
I know. It's true. Sorry about that. Seeing none, that concludes the testimony on Senate Bill 777. Let's go now to Senate Bill 851, Baltimore City Administration Bill being presented by Senator Carter.
Thank you again, committee and Mr. Chair. So this bill was brought to me by the Baltimore City Administration, and they have a mandate under the consent decree to access records of law enforcement officers or potential law enforcement officers in the hiring process. But of course, some law enforcement officers can make their social media private. And the consent decree actually requires that their social media be considered if they have it. The bill as it came in would simply have allowed, in compliance with the consent decree, that law enforcement agencies in the hiring process would be entitled to access to these to the social media. However, a task force or a work group was formed within the Senate Finance Committee, and everybody was on it, including the FOP that was the staunchest opponent, and also the Baltimore City Administration and several of the senators on that committee. And they came up with 2 amendments that I think everybody's happy with. One of them is that the new language with the amended bill ensures that law enforcement agencies would not hold on to password information once they receive it any longer than they needed it for that initial check. And then number 2, that if a law enforcement agency did access the social media of a potential employee, that potential employee must be physically present as they are going through it. And so everybody seemed happy with that. Again, the bill was designed to do 2 things: to allow the law enforcement agencies to do a thorough check of the type of person that they're hiring and what they might have posted on social media. There's been a lot of instances where it's been found that officers have posted horrific things on social media. And the second thing is to comply with the consent decree, which the Baltimore City Administration says access to the social media of their officers and hirees is mandated under that decree. And briefly, initially, the city had 3 bills. One of them, I think that the Senate decided went a little bit too far, and so we didn't pass it, which would have said that the consent decree trumps state law when it comes to these issues. And so I think that is going too far. But I think this is a little teeny fix that enables Baltimore City to comply and also doesn't cause, really a privacy violation, because it ensures that they don't hold on to a password longer than they need it. And so with that, I'll take any questions if I can.
Any questions? Delegate Bartlett's hand, I think, is up from the time before. We're all outraged, but we've gotten over it. Any other questions for Senator Carter? All right. Seeing none, we thank you very much. And that concludes the testimony on Senate Bill 851. Thank you very much.
Thank you.
All right. 2 bills now from Senator Bailey. We'll hear from him for Senate Bill. Let's hear Senate Bill 517 first. Senate Bill 517 and then 581. So Senator Bailey, there you are. Let's hear from you for Senate Bill 517.
Good afternoon, Mr. Chairman. Good afternoon to the distinguished members of the committee.
Oh, and Senator, I'm sorry, I should have said there are 2 members of the Economic Matters Committee here at least. And I see Delegate Mouts, Delegate Brooks, who are here. So they're going to be joining us. If they have any questions, I might call them on. I don't know. I haven't decided yet. I'm hard to read. All right, Senator Bailey, go ahead. I'm sorry to interrupt.
Cut right to the chase. The purpose of this bill is to save lives of missing persons. When first responders are looking for missing persons, minutes and seconds matter to find that person while that person is still alive. This Senate bill is based on legislation that has now passed in 30 other states. Law enforcement officers in Maryland are currently able to obtain information in accident circumstances, but in these searches for people, it routinely takes hours and sometimes days after the request, as the law does not require service providers to comply in a timely fashion. This bill limits agencies requesting local information to a maximum of 48 hours and provides that a person who complies with this law cannot be held civilly liable. Now, this bill that you're hearing is similar to the crossfile, which was House Bill 1053. But this Bill 517 was substantially amended in the Senate to address these privacy concerns. The provisions of this bill now only apply to a person who has been reported missing and includes safeguards to prohibit law enforcement officers from obtaining this location information if a person has not been reported missing. The Senate amendments remove all references to exigent circumstances, and it provides that the person is notified about the request and the reporting requirements. With these amendments, the bill passed the Senate 46-0. I respectfully request a favorable report on Senate Bill 517.
Questions for Senator Bailey, please? Seeing none, we thank you very much. And that concludes the testimony for Senate Bill 517. We thank our friends from the Economic Matters Committee for being here today as well. Thank you very much. We're now going to go to the second bill, Senate Bill 581. So Senator Bailey, if you'd like to begin with that for three minutes.
Mr. Chair, there is a witness for SB 517.
Okay, but I believe we heard this bill already on the House side, so this was a sponsor-only hearing.
Okay.
Yeah, I believe that's accurate. I now see it. The Yannon Emanuel from the ACLU. I mean, okay. All right, they are listed here. I believe that this was a cross-filed bill, so I believe that we already held the full hearing on this. So I'm going to refer the committee to the written testimony from the ACLU regarding Senate Bill 517, and then we will go from there. But I will ask Senator Bailey now to go forward with Senate Bill 581, please.
Mr. Chairman, again, distinguished members of the committee, Senator Bailey, for the record, District 29. This afternoon, I'm going to talk about Senate Bill 581, Public Safety Law Enforcement Agencies Positive Community Feedback. This bill would require law enforcement agencies to maintain a record of positive community feedback for all law enforcement officers within the agency. This directs the Maryland Police Training Commission and Standards Commission to develop a uniform process to collect this feedback from members of the public. These records would be subject to public inspection in accordance with the Maryland Public Information Act. Last year, the committee devoted a significant amount of time and effort on making changes to Maryland law so that the public could be more informed about the record of police officers. I believe that this bill is consistent with those efforts. This bill contains provisions which would create a simple, accessible, and uniform process that can be implemented by all law enforcement agencies in the state. When it is possible to implement such a process on their own, this bill ensures that all law enforcement agencies in Maryland have this information on file and ready if requested. A uniform standard would make it easier for these agencies to implement this initiative and create a fair process. Allowing positive reports and information about an officer to be collected, released, and reviewed would provide a clearer look at the officer's whole reputation. In law enforcement, an officer's reputation and future depends on that reputation and character that they've built. This bill would help to provide a total picture of the officer's work. These are our first responders and the men and women who protect our families and our community. Assuring our law enforcement officers that their full record would be available if their reputation is questioned or challenged will be beneficial to recruitment, retention, and the future of policing in our communities and in the state. When I attended Johns Hopkins, this was one of the questions that we looked at, and we called a lot of police agencies and we said, where is the positive feedback? What if you call a dispatcher? And routinely we found very much old school. The paycheck they get every 2 weeks is the thank you that we give them. The agency that I worked for, the Natural Resource Police, I had them last year engage in this process, asked them if they would mind. They said no problem. They did it per 100 calls that they received, dealing with complaints or compliments. 60 were complaints, 40 were compliments. For many agencies, this is simply lost in space. None of them are tracked or recorded. And this just enables agencies to be able to track that and for the officers. This bill passed the Senate 46-0. I respectfully request a favorable report, and I thank you all for your consideration.
All right, now for questions, Delegate Shetty, please.
Thank you, Mr. Chair. Thank you, Senator, for bringing this bill. I think I understand the intent here, but I'm just curious. I'm looking at the language of the bill. Do you anywhere in the existing language of this bill define what positive community feedback is? I mean, I think intuitively we might know, but I'm just curious if you have a definition in mind.
So I do not have a complete definition recorded in the bill of positive community feedback. I mean, there are definitions for things that are negative and when there's a complaint made, when it's a code of conduct violation. And my thought is if a person called in other than a violation, that would be positive community feedback.
Okay. So I guess where I'm sort of trying to drill down a little bit is on the word community. In theory, could somebody from within a fellow member of the police force who also happens to be a member of the community, could they call in with positive community feedback?
They could.
Okay. So
there would be no difference in a member of that community filing a complaint or a compliment.
Okay, so then a fellow officer, maybe like a law enforcement partner, somebody could call in essentially to put in another officer's record, you know, all of the nice things that they have to say about that officer who may also be potentially under investigation for alleged wrongdoing. So this could potentially slant the file or balance the file with compliments from other officers within the force.
So I think there is a potential that somebody could in fact call in a false positive community feedback.
I mean, I'm not even alleging that. I'm just saying that, like, it could be like, you know, Joe is my friend. He's a really good person. I have lots of good things to say. I've seen him every day working hard for the community. So it's not necessarily false, but it is intended to provide quote unquote balance to the record while Joe is also being investigated for alleged wrongdoing.
So I think that's Delia, I think that's potentially a possibility, but I think that in the totality of the situation, I think that if somebody was under investigation and all of a sudden you started getting you know, people calling in and saying, well, here's an example. This guy's really a good guy because of this incident that happened, you know, years ago. I think that very much would be what it is. And we would see that for the exact scenario that it exists.
Okay, thank you, Senator. Yeah, I understand the intent of the bill, providing maybe a more balanced view of an officer's record and accomplishments on a force. I'm just curious about how this could be potentially exploited by others who, you know, may not have necessarily, may or may not have good intent. Thank you, Senator.
Thank you.
Delegate Crutchfield.
Thank you very much, Mr. Chair. And Senator Bailey, thanks for coming with this bill to us. I just have a question. I want to make sure I understand, because I'm thinking that this bill just is making sure positive feedback is put into the personnel file of law enforcement. Is that correct?
Well, so it is actually being given, what this bill does is it gives the task of developing the Maryland Police Training and Standards Commission about where they're going to do that. Right, they're going to actually adopt a policy so that every police department treats it the same way, right? And so that way it's not willy-nilly done by one agency different than another.
Okay, but already I would think that agencies can do this, right? I mean, if there's positive feedback, a law enforcement agency can go ahead and put that into the personnel file already, correct?
So there's certain rules and regulations that concern putting something into a person's personnel file. And as my experience has been, there are a few agencies that I have heard of that do this, but for the large majority, if it is not a complaint, it is another piece of paper that they would have to fill out. So they are not worried about doing that.
Okay, so you just can't put in any kind of positive feedback is what you're saying.
That's correct.
Okay, thank you.
Delegate Cox, then Delegate McComas.
Thank you, Mr. Chair, and thank you, Senator, for this good bill for our law enforcement community. I just wanted to follow up on some of the comments, and I think I think you answered most of it about in terms of the disclosure process. I think also the question would be balance. I like that term that was mentioned because I think, and Claire, maybe you can address this, but right now, isn't it true that the individuals in jail can file complaints without being sworn under oath against officers? In other words, they could file, and the potential is there for false accusations being filed against officers as well, from people actually in jail at the moment.
That's correct.
So I just appreciate the transparency. I think that's helpful. And when it says specifically that positive community feedback will be maintained, I mean, this is something that the community provided and the community can then see it. So if there's, 20 different filings from one person, I guess the community will be able to make their own judgment as to what that, is that fair to say? It would kind of demonstrate transparency in terms of these positive and negative comments.
Yes, Delegate, and I appreciate you saying that. The whole situation is, we are going through a complete transformation in policing, and the scenario is that 35 years ago when I started, it didn't matter what you saw. It didn't matter what you came upon. The fact is you were a policeman, you've been trained, and you deal with it, right? And all the things that you took home with you in the evening, so many people took it out in different ways that they shouldn't have. And now what we are addressing is getting people a lot of the training and in-depth education across the board. And this was one of the things when I was doing my graduate work at Hopkins, and we started calling all the different police departments. This was the one thing that stuck out so clearly, even when we talked to the chiefs. They were not in a position to recognize this, and so many of them, having been people that came along in the other way, they were like, you know what they get? They get that paycheck, they get their leave, they get the other things. Their reputation, that's something they built in the court system, right? But that all was very, very different because, personnel files were then, they were very restrictive and they were always kept. And now that they're going to be public, I think from being in that realm, that it's very important that we are very transparent. And I know that there's an old saying, especially in the military where they captured both. How many attaboys did it take to get rid of one, oh shucks? And I think that back then I've heard it was about 7-1. And I'm not saying that at all. I'm just saying that right now there's no mechanism in Maryland law enforcement for us to keep any positive feedback. And if we're going to judge the officers, we should create this. And that's why we gave this to the Maryland Police Training Commission, so that that way they can come up with the standards and be able to figure out how to uniformly do this across the board.
Thank you. And I just wanted to note too, I didn't see any negative testimony at all. It was all positive. So thanks for bringing the bill.
Thank you.
Delegate McComas.
Senator Bailey, it sort of, to me, it indicates that you kind of get a larger, more balanced picture of your employee if you're allowed to kind of document compliments or a good job. And I guess I'll ask you this. I would suspect that if somebody does something very heroic and it gets some press and everything, and maybe even gets a citation from the town board or the sheriff's department, that might or might not go in their personnel file. Is that fair to say?
That might go in their personnel file. Yes, ma'am.
But then again, it might not, just depending on, because I would assume each agency maybe controls what goes in or out of their personnel files for their employees, law enforcement.
And as an employee, you can request that an item be submitted to your personnel file.
But I'm just wondering how often that's done, because I know in my jurisdiction, we've had police save people's lives. We've had, people save animals from, burning building. I mean, a lot of different stuff that the police have done. And I don't know, and the town would celebrate them, but I'm not sure those certificates ever went in their personnel files.
So I think that would be dependent upon the officers, and it would be definitely dependent upon the administrators in that department. There is no uniform ability to do that, and that's what this is. That's what this bill is creating: uniformity across the board.
I think it's a good bill. Thank you, sir.
Thank you.
Any further questions? Seeing none, we thank you very much, and that'll conclude the testimony for Senate Bill 581.
Thank
All
you.
right, that concludes the bill hearings for today. I'm going to ask, we're going to have a subcommittee chair meeting here. Let's start at 2:20, and we will vote at 2:45, voting at 2:45 this afternoon. So we'll be back here in a little over 35 minutes. All right. This has been the House Judiciary Committee. We'll be back in just a few minutes. Thank you.